So I'd like to thank Alan Klinger and Daniela Tisch as heads of the Fall Conference Committee. The names of everybody on the committee are on the back of your brochure, and they really spend a lot of time going over what topics to discuss, and this was one of the topics that they came up with. And then we go to the law school and we say which student groups are talking about these issues so that we can partner with them. And just so happened the Supreme Court Reading Group was addressing this very type of issue. And we're sorry that Robbie Kaplan is not enjoying pizza and beer in a small group setting. But she looks okay. She looks okay about that. I'd especially like to thank the Supreme Court Reading Group, who's here today, and Gabe Panic, who runs that group, and introduce you to Gabe. Thanks so much.
Thank you. Oh my God, yikes. I must say this is the classiest event we have ever done by a factor of about 50. So thank you for joining us. And thank you so much to Karen and the Law Alumni Association for helping to put together this really wonderful event. I'm very excited that we're able to take our very focused interest in recent cases before the Supreme Court and able to speak with, our events focus on speaking with professors and practitioners and making that accessible to students here at NYU, but that through the Fall Alumni Conference, we're able to bring that to a broader audience. We're very excited to be able to do that through this event that I think will be really exciting. And Dean Morrison will be along in a minute, and I will introduce him, although I'm sure he really doesn't need any introduction. I think we all know who Dean Morrison is, but he's also our advisor, which I think is his most important position, personally. I'm sure he shares that opinion as well. But so the Supreme Court Reading Group, just to tell you a little bit about us, it was founded 2 years ago, as for the reasons that I said before, and we've been able to speak with a lot of people, mostly professors, but the first person when I was brought in as president earlier this year, the first name on our list for people we wanted to be able to speak with, have an event with this year was Roberta Kaplan. And so I met with Dean Morrison, who somehow had time to talk with me, and I was sort of trembling. I said, wow, Roberta Kaplan would be great. He said, oh, Robbie, of course. Oh my God, okay, well, fine. So those are the benefits of being able to work with Dean Morrison on all of these. And he's been a really, truly great advisor. His commitment to this group is how I've been able to work with him, but it really speaks to his commitment to student and academic life at this school. He seems endlessly busy, and yet he's always willing to talk to students and get involved with student life as necessary. And he's been, in his years since being named dean, I think a really positive presence, both for our group and for the school. And I would finally just like to thank Roberta Kaplan for agreeing to come here tonight. I think it's going to be an engaging and fascinating discussion that we'll have over the next little bit for all of you. And it's been a privilege to work with her and the fine people at Paul Weiss and Dean Morrison. And so now I would like to introduce Dean Morrison. Thank you. And thank you for coming.
Well, thank you, Gabe, and thanks for your leadership of the Supreme Court Reading Group this year. I think it's a terrific new student group. And welcome to all of you. I think this is a great continuation of a trend we started in the last couple of years of collaboration between the Law Alumni Association and student journals or groups and putting together this annual event. And so this is this year's edition of the LAA annual conference is this talk with Roberta Kaplan. I'm going to call you Robbie even in this setting. Does that work?
Please do.
And it is, among other things, really a celebration of her terrific new book, Then Comes Marriage, many copies of which are outside there, I noticed. It's a fantastic read as a story or set of stories. And also really gives us insight into what I think will surely be remembered decades from now as a turning point in U.S. constitutional history, as a turning point in U.S. history, and indeed as a turning point in history, take it the U.S. modifier even. And if there was an architect of all of that, it was Robbie Kaplan. So we're very, very glad to have her here this evening. A few words by way of background biography. Robbie, she committed a mistake that has been known to happen, and for which I can report blissfully that forgiveness abounds here at NYU. She went to Columbia Law School. And yet, so the correct answer is imagine what she could have achieved with an NYU degree. After graduating from Columbia, she clerked for Judge Mark Wolf on the U.S. District Court in Massachusetts. And she also, after that, clerked for our graduate, Judith Kaye, on the New York Court of Appeals. She initially joined Paul Weiss in 1991, then returned after the second of the two clerkships, becoming partner in 1999. She really is a standout, well before the Windsor case, is a standout litigator, principally a trial litigator, known for handling a whole range of very, very complex matters, and known as the kind of litigator who wins cases, which is different from some ways to describe other litigators. But
Better than the opposite,
yeah,
definitely.
correct. Someone who handles very sophisticated cases, and who is a tough, tough adversary in the courtroom. And then came marriage, but then came United States against Windsor. And Windsor, as you all know, is the Supreme Court decision that ultimately struck down as unconstitutional the key provision of the Federal Defense of Marriage Act, or DOMA, that really purported to define what marriage was for purposes of federal law, and to declare that it meant only the married union of one man to one woman. And so it's that definitional provision, really, then, that by its terms purported to govern every other federal law that referred in any way to marital status. And so it had in this one statute this kind of panoptical set of consequences across the entire United States reports. And it was then this decision that struck down that provision as unconstitutional, and really that I think kind of paved the way for what was to many of us an inevitability, which was the Supreme Court's decision this past term in Obergefell, holding that there was in fact a constitutional right to marry, applicable not just at the federal level in terms of federal statutes that are unconstitutional because they discriminate against same-sex unions, but applicable at the state level then, that rendered unconstitutional state marriage laws that made that licensed union available only to heterosexual couples. So that's a major set of consequences, to put it mildly. To put this in broader context, as recently as 2003, the 2002-2003 term at the Supreme Court, there were still laws on the books until the end of that term, laws on the books in various states around the country that were deemed perfectly constitutional, that far from merely discriminating when it came to marriage, held it to be a crime to engage in sexual intimacy between two consenting adults if they were of the same sex. So that we have come from there to where we are today is a remarkable story that many people have remarked upon. The central role of the Windsor case and the central role of Robbie Kaplan in the Windsor case, I think, is a chapter that everyone would agree is a key step, but that in some ways needs to be recognized as even more central, I think, than thus far it has been. And it's one reason why I'm so happy that this book is out, is that I think it documents this, how deeply consequential the Windsor case and the equality language of the Supreme Court opinion that ultimately resulted, the equality-focused language in that opinion that ultimately resulted. But that's me editorializing a lot. We'll get more on this from Robbie, but why don't we start a little before Windsor. Robbie, why don't we start with you and the law? Had you always known, were you one of these kids who grew up knowing you wanted to be a lawyer? And was it fulfilling that early plan that brought you to law school? And what kind of lawyer did you imagine you would be on graduating from law school?
Yeah, so this is kind of embarrassing to admit, but the basic answer to Trevor's question is yes. I grew up in Cleveland, Ohio, and when I was a kid, I liked to talk a lot, shockingly. There's this great letter. My uncle was in the Peace Corps during the Vietnam War, and there's this great letter that my grandmother wrote to him where she said to me when I was like 2, Robbie, can you please, you have to talk all the time. Can you please just not talk for like 2 minutes? And I said to her, but Grandma, I just love to talk. I just can't not talk. And at a certain point, I realized, or I heard, I think, that if you're a lawyer, you get paid to talk. So I thought, as far as I was concerned, that was the perfect job for me. And I knew that's what I wanted to do. And then a few years later, it gets even more embarrassing. My mom had a subscription to New York Magazine and The New Yorker, and Ms. Magazine. And I used to read each issue avidly when it came. And about at the age of 10, I decided that I was going to move from Cleveland to New York, that the way I would do that would be to go to an Ivy League college and then go to law school in New York at 10. It's totally scary. And that's what I ended up doing. I went to Harvard and then Columbia, and I knew immediately at Columbia I wanted to litigate. And I kind of went to Paul Weiss because Paul Weiss was known then, and I hope still today, as being such a great litigation shop. And I figured it would be a great place to learn how to do that.
Mm-hmm. Was there a particular area that you were thinking you would focus your career in at that point?
Not really. I mean, the great thing about Paul Weiss, again then and still today, I think, was this really strong sense that we have that the skills of being a litigator are the skills of being a litigator. Mm-hmm. And that putting together the facts, citing cases, being convincing, having credibility, telling a story, doesn't matter all that. I mean, there are areas that are obviously very specialized, patent, antitrust, et cetera. But if you have that ability, you can do it across a whole range of areas. So we used to joke that my specialty was fraud. In almost all the cases I did, I wanted to prove that someone was lying to someone about something. And it didn't really matter what the substantive law was, as long as I could prove that or disprove that. So I didn't really, I wanted to be a trial lawyer, but I didn't really have a strong sense, until I started getting involved in the gay equality stuff, I didn't really have a strong sense of a particular subject matter area.
Mm-hmm. And when did you start getting involved in gay rights questions as a legal matter, gay equality questions?
So it really started, I talk about this in the book, when I was clerking. I clerked for Judge Kaye during in 1994, 1995. And at the Court of Appeals, you get, they probably get 2, 3, or 4 really big cases a year. And one of the big cases when I was there was called Matter of Jacob and Dana. And the question presented in that case is whether essentially gay people, there was actually a straight couple and a gay couple, but essentially the question in the case is whether a gay couple could adopt so that the 2 women who had been raising this kid together would both be the mothers. In New York law, there was a construction of the New York statute that said that couldn't happen because it would terminate the biological mother's maternal rights. And I worked with Judge Kaye wrote, but I helped her on the decision in that case, and it was very dramatic because I was totally closeted at the time, totally closeted to Judge Kaye. Not closeted to certain people, but to a lot of people I was very closeted. When the case first was voted, it was at the end of the spring, Judge Kaye had the dissent. It was 4-3 the other way, and she held the case over the summer. And in August, we got the 4th vote from Judge Levine, who's since written about this, I understand, himself. Mm-hmm. So that's really, it was this incredible thing where I was incredibly involved in it. It was this incredibly momentous thing to allow gay people to adopt in New York. It sounds funny today. But I was totally in the closet.
Wow.
I was always I had this kind of crazy fear that Judge Kaye was keeping memos from me because she knew I was gay but didn't want me to see them. And I've since talked to her about it. She's like, that's totally not true. I have no idea.
The adoption issue we'll come back to because it's one area that remains a live issue today in some states. But let's bring your client in Windsor into the picture, Edie Windsor. I think she's known, whether or not personally, certainly known of to many people here, but tell us a bit about her and tell us how you first met her.
Sure. So let me kind of tell the story of how I first met her, or how I first kind of knew who she was, and then I'll tell the wonderful story of her life. Well, I'll do it the other way. Let me tell the story of her life. So Edie was born in the 1930s during the Depression in Philadelphia. Her father was in the candy business. He had a candy store, and they lost their business and their home actually during the Depression. They moved in with relatives. She went to Temple University, and while she was at Temple, she fell in love with a woman. And she realized for the first time that she was a lesbian. But in her words, this was the 50s, early 50s, the idea of being a queer, her language, was inconceivable. Makes sense. I don't know if anyone's seen the movie Carol, but that's kind of what it was like. Was inconceivable to her. And so, needless to say, the relationship didn't last. And she broke it off, and then she graduated. And she ended up getting married to a guy by the name of Windsor. That's how she gets the name. He was her brother's best friend. They had fought together in World War II, and they had graduated college at the same time, because after World War II, they were both had GI Bill benefits, and they both went to college at the same time. The marriage didn't last very long. After a matter of only months, Edie said to her husband, "You deserve to be loved really the way you deserve to be loved, and I need something else." And like many people, including myself, a few decades later, she moved to New York City in order to be gay. The nice coda to that story is that Edie and her husband stayed friends. He called her on her 70th birthday. He has now passed away, but since winning the case, Edie has become very close to his wife. And they've gotten together on a number of occasions, which made Edie feel much better that her wife knew about everything, and they've actually become very close. So Edie then moves to New York. The bigger issue then, frankly, was not being gay, because anyone who was gay at that time, unless you were really willing to live on the margins of society, you had to be in the closet. Almost anyone was in the closet. The much bigger issue was being a woman, because Edie, I know what everyone knows what she looks like. She was a looker. She still is a looker. And she'd always assumed that she'd get married and her husband would support her. And now she realized she had to support herself. She had been good at math in high school, so she decided to enter the math program here at NYU, which she did. She became one of the earliest computer programmers in the country. In order to earn her way through grad school, she got a job working on the UNIVAC computer, which took up apparently a city block somewhere very close to here, and that was operated by the Atomic Energy Commission. So one day, she's at her apartment, and she gets a letter from the FBI. And the letter says, "We'd like to talk to you about your Q, no pun, your Q security clearance to work on this computer. We don't think you need a lawyer yet, but we'd like to speak to you." Edie was terrified, because she knew, and it was true, that at that point in time, it was a felony for anyone who was a homosexual to have any employment whatsoever with the federal government. Indeed, Edie went on to an illustrious career at IBM, and for much of that period, it was frankly illegal for her to be at IBM, because IBM had contracts with the federal government. So Edie did some research under New York law. Turns out she was a very good young associate. Her research was correct. And it turns out for a lesbian, as opposed to a gay man, and the laws were very different, for a lesbian back then, what was illegal under New York law was to appear or dress as a man. So Edie shows up at her FBI interview in high heels, frilly dress, and crinolines, hoping, as she said, to throw the FBI off their game. Fortunately for Edie, and I would say fortunately for the country, all the FBI asked her about was her sister's friends who were in the teachers' union, who they thought were communists. And she got her security clearance, and they never asked her whether she was a lesbian. Why do I mean, they're both great stories about her first marriage and about the FBI interview, but they're so important in terms of telling the story of how gay people used to live their lives. And legally, they ended up being so important on the issues in the case that were fundamental, like, can you change being gay, right? The other side wanted to show that Edie's marriage somehow proved that she had a choice about being gay. Well, we were thrilled when we got that request, because obviously her marriage shows the opposite, right? If she had a choice, she'd still be married to Saul Windsor, or she'd be living on the main line in Philadelphia with a bunch of grandkids probably. So she's then back in New York. She graduates. She gets a fellowship at Harvard, which she goes to for a year and doesn't like, because apparently they didn't teach software programming at Harvard back then. So she comes back to New York, and she's very lonely. And one night, kind of in desperation, she calls a friend and says, "Please, if you know where the lesbians go, could you take me there?" So her friend takes her to a restaurant called the Portofino, not far from here in the West Village. It was then managed by Elaine Kaufman, who went on to start Elaine's. Sitting there at the restaurant, a woman by the name of Thea Spire comes over to the table. Now, Thea came from a very different background. Her family she had grown up, or her family was from Amsterdam. They were very well off. They had the Spire pickle business in Amsterdam, and then they actually brought it over here when they emigrated. She left Amsterdam with her stepmom as an infant, kind of when the stuff about the Nazis was growing. Her dad stayed and then joined them just as the Nazis were invading. She spoke a zillion languages. She was a brilliant violinist. She knew everyone. She was a fabulous golfer. And Edie, from Edie's perspective, it was love at first sight. Not so for Thea. Thea was involved at the time, and unfortunately for Edie, kept being involved for the next 2 years with a variety of different women. And Edie finally heard that Thea was no longer attached and was going out to the Hamptons for the weekend. So Edie called some people who she actually didn't know that well and said, "Would you mind terribly if I come and stay with you this weekend?" They said no, and needless to say, that's when it all started. And 2 years later, in 1967, they were driving out to the country, and Thea pulled over by the side of the road and said to Edie, "Will you marry me?" She gave Edie a circular diamond pin instead of a ring because they had talked about this, and Edie had said if she showed up at IBM with a diamond ring, everyone would say, "Who's the lucky guy?" And Edie couldn't answer that question. In fact, when she would get questions about Thea at work, she would say that she was dating Thea's brother, Willie. There is a Willie. He's a Dutch wooden doll. I've seen him. He actually lives in Edie's closet. But the idea that two women in 1967, 2 years before Stonewall, think about it, 2 years before Stonewall, could even have the thought in their heads to get engaged, frankly, never ceases to amaze me. Then the truly heroic part is what happened for the next 40 years, because about 10 years into their relationship, Thea was diagnosed with a terrible form of MS. She lost the use of her legs and then her arms. By the time she died, she was totally paralyzed. They had a refrigerator magnet in their apartment that said, "Don't postpone joy." And they truly lived those words. And in fact, on the day that Thea died, she was a psychologist. She had 2 patients she was supposed to see who had to be told what had happened. When she died, they got married in Toronto in 2007. When Thea died in 2009, even though Edie knew she was going to have to pay an estate tax because their marriage was invalid under DOMA, I don't think she'd really realized the full extent of it. They had an apartment just across the park, which, as you can imagine, had appreciated in value over the 30 years they lived there. And she said she felt indignant at the idea of having, it's a great word, it's amazing she used that word, indignant at the idea of having to pay this tax bill. So she went around looking for a lawyer, and fortunately she found me. And that's when it all began.
How did she find you?
So what happened is she had gone to some of the gay civil rights groups and had been turned down. But Edie's, I was going to say almost as stubborn as I am. She's probably as stubborn as I am, maybe more stubborn than I am. And so she kept at it, and she talked to a friend of hers, Brendan Fay, who was an activist, who is a friend of mine, who's actually a legal headhunter. And he asked him if he knew anyone. My friend said he was going to call a bunch of people. On the day that our case was accepted for cert at the Supreme Court, we were all together, all 4 of us, for the first time. And my friend admitted that he only gave Edie's number to one person, which was to me. When I got the call from my friend, I had never met Edie, but I knew exactly who she was. And the reason I knew exactly who she was is not because she was the icon that she is today, but it's because 18 years before that, I had been in my 3rd year law school at the other law school. And it's fair to say, I think for me, I was kind of a late bloomer in terms of coming out. I certainly thought about it at college and didn't do anything. I certainly thought about it in law school and didn't do anything until the bitter end of my 3rd year. And it was my bad luck. Shortly thereafter, my parents were coming to visit for the weekend. And even worse luck, it was Gay Pride. And so as my parents kind of wound their way to my apartment on the Upper West Side through the parade, by the time they got to my apartment, they were kind of in a state. My mom kept talking about what is everyone so proud of and what's with all the rainbows. And my college roommate's mom was Ruth Messinger, and she had led the parade. And my mom kept saying, "What's Ruth Messinger so proud of, and why is she leading the parade, et cetera?" I said to my mom, "Please stop." As mothers and daughters are wont to do, my mom continued. I finally said, "Stop" again, and she said, "Why are you gay?" And I said, "Yes." And she went over to the corner and started banging her head against the wall. We can laugh now. It was not funny back then, trust me. People say it's like Seinfeld, but it was like Seinfeld way before Seinfeld. And as you can imagine, well, let me just say before I go on, my mom's apologized for this 10 million times. It's not a criticism of my mom. She could not be more proud of who I am today. Like many other people, she's evolved on this, and that's fine. That's to be celebrated. But at that point in time, I was a little depressed, I think it's fair to say. I was moving to Boston to clerk. I was in New York City for the summer, and I went around asking, I need to see a psychologist who's good at gay issues. That's the way you talked about it then. And I kept getting the same referral. The name I kept getting was Thea Spire. So believe it or not, this is where life is just incredible. I saw Thea Spire as a patient twice in 1991 in the same apartment where I met Edie 18 years later, because Thea was already paralyzed, so she saw patients in their living room. The most incredible part of it all is that she talked about Edie during those sessions. And I'm not a shrink, but I don't think shrinks are actually supposed to talk about their own lives with their patients. But I think looking back on it, she was so convinced that the only way she could persuade me that I was so despondent that I could have the life I wanted, is to tell me about her life with this woman named Edie Windsor. So 18 years, flash forward 18 years, I walk into the apartment. I said it was like coming back to like the scene of an accident. Like all the emotions came back. I said to Edie, "You got to give me a minute. I've been here before." I explained to her why. Then the second thing I said to her is, "You so don't look the way I imagined." Because Thea had described her as being this brilliant mathematician. So I kind of imagined like a woman with like thick glasses and a slide rule and kind of a flannel shirt thing going on. And then I remember thinking, God has given me this opportunity to pay Thea back for helping me the way she did, and I'm going to do it. Bizarre, I know. I know it sounds corny, but it's true.
It is an amazing story. It is, you had to have this case. Now, that's a separate question from whether this had to be the lead case challenging DOMA, because there were other candidates, and there certainly was a view at the time that, in the language of the Supreme Court, maybe the Windsor case wasn't the best vehicle. Yeah. Maybe these weren't the most sympathetic facts. After all, this was a rich person's case.
Yeah.
This was not about Social Security benefits, for example, which another case could have presented. I think you faced some amount of skepticism from some within the community, the legal community, on this.
That would
the
be
gay
fair
rights
to
legal
say.
community. How did you deal with that?
Well, so, I remember I said that Edie had been turned down by the gay rights groups, and I think one of the reasons she was turned down is because this concern that having to pay, her tax bill was $363,000, her federal state tax bill, that she would be perceived as this kind of privileged, white, rich lady, and that wasn't the image that the movement wanted to project nationwide. I had a couple reactions to that. First of all, when Edie first came to me, I thought we would win the case in the Southern District and the Second Circuit. I really wasn't thinking about the Supreme Court. I knew a case would ultimately get there, but I didn't think it would necessarily be ours. But I thought Edie would get her money back, and I, as a lawyer, I couldn't in good conscience tell her to just waive that claim. I mean, it was a very strong, I thought, viable claim, and in order to get it back, she had to sue. You can't preserve it any other way. We weren't going to get a tolling agreement with the government. So there was that. Second of all, part of this is probably based on my background of representing big corporations and pretty privileged people, but in my perspective, like Edie is obviously well off, but she's not a hedge fund or a private equity person. And most of the reason for the tax was the fact that, as I said, they bought an apartment in 1979 and it appreciated hugely. I also thought the tax context was fabulous. First of all, I've been watching this show Liberty Kids with my 9-year-old son about the Revolutionary War, and it You know, as I recall, assuming Liberty Kids is correct, our country kind of began about a fight about unfair taxation, number one. Number two, this was
I can confirm that, yes.
thank you. This was a huge damage, right? This was this wasn't just a little, like, one of the cases out there was a bankruptcy case where there's a filing fee of $150. Not that that isn't a damage, but $363,000 is really damage. And then three, we kind of had the added bonus. I thought every American would get in their gut what it means to have to pay an unfair tax. And then we kind of had the added bonus that the Republicans don't even like the estate tax. So I kind of liked the fact that it was an estate tax case. And I thought this fact that it was essentially a death tax on being gay, you know, kind of made it so powerful. But this was not there was a lot of dissension about this. I think over time, as Edie herself became so popular and became such a symbol, those objections kind of died away. But there was and I also thought, frankly, once we got close enough to the Supreme Court, my view was that you have to think about who your audience is. And I thought that the justices of the Supreme Court, many of whom are Edie's contemporaries, really would be able to relate to her story. I wanted them to think of her marriage as being like their marriages. And we felt that if we could do that, we would win the case.
So let's talk about, there'd be a lot to talk about in the lower court stages, but just fast forwarding to when the case is sort of between the Second Circuit and the Supreme Court. You are, as I said, were before this case, a hugely accomplished trial lawyer, and known as that. And in other contexts, there's a pretty common phenomenon these days, which is when a case gets to the Supreme Court, a different set of folks intervenes or proposes that they intervene, namely the Supreme Court bar. And there's, as you know, a relatively small number of people, most of them based in Washington, D.C., who have each argued dozens of cases before the Supreme Court, typically some in government and then in private practice. And surely all or nearly all of them propose to help out in the case in one way or another. You kept the case, and you now bat 1,000 in front of the Supreme Court.
I should probably keep it that way.
So tell us, tell us about this. Was there pressure to pass the case off to a sort of more recognized figure within the Supreme Court bar, if I could put it that way?
So no one, I'm trying to remember, I don't think anyone actually had the gall to say it to me directly. But this sense that I should pass off the case, we should pass off the case to a member of the SCOTUS bar, I would say it would be fair to say that the atmosphere was pregnant with that sentiment, wherever we went. And I was very well aware of it. And when it became a possibility that we would get to the Supreme Court, and the Supreme Court actually, the Solicitor General filed this very strange, unusual device called cert before judgment in the California case, the Galinsky case, and we realized that was a real possibility. I knew that we needed kind of a member of the SCOTUS bar to kind of help out on our team and to kind of be the person to guide us. And I'm going to have to give a plug to another law school now, but so we're kind of thinking about who to call and what to do. And I heard about this woman, I didn't know her from a hole in the wall, named Pam Carlin at Stanford. I knew she'd argued a whole bunch of cases. I knew she was the co-founder of the Stanford Supreme Court Clinic. And on July 4th, I actually had the chutzpah out of the blue to send her an email saying, "Hi, I'm Robbie Kaplan. You don't know me, but I have this case called the Windsor case, and would you like to help out?" And she emailed me back within minutes in her bike shorts. We spoke on the phone. She was actually going to go to Italy that semester to teach. She canceled her trip to Italy and became an integral member of our team, really my co-counsel on the case. And then later, when the court took our case, I was all this pressure about whether I should argue the case or not. I actually called her and I said, "Look," I said, "I want you to know that I'm thinking about whether or not I should argue the case. I said, I want you to know that if I don't argue the case and Edie accepts my recommendation, because ultimately it's her call, I will recommend that you argue the case. And with that, I want you to tell me, what do you think? Should I argue the case?" And I have to say, she really didn't hesitate for a second. She said, "No, you should argue the case. It's your case. There are things about arguing in the Supreme Court that you have to learn that are different, but you can learn them. We'll teach you, and I can teach you that. But you should do it. I don't know what kind of blessing I had in calling Pam Karlan. I'm not sure there was many other lawyers, if any other lawyers, who would have given me that answer. It kind of is a tribute to the kind of human being that she is. So after she said that, I knew she would tell me the truth. And then we got to work, and we spent 3 months pretty much full-time preparing for first doing the brief and then preparing for the argument, which was probably not the most stress-free period of my life, fair to say.
Well, I want to talk about some of the argument preparation in a second, in particular the moots. But just slightly back at the briefing stage, really, this complication arises in the case, to put it mildly, right? Which is that the Obama administration decides to argue in its papers that sexual orientation-based discrimination should be treated in the constitutional law doctrine with heightened scrutiny, and that DOMA fails to pass muster on that. So this is the government, otherwise charged with defending the constitutionality of federal legislation, that is taking the position that argument just isn't even plausible, so that the Solicitor General's otherwise very strong obligation to defend the constitutionality of a federal statute doesn't apply in this case. So there's what to make of the merits of that argument, but I want to argue about the kind of I want to ask you about the procedural and jurisdictional complications. This raised questions, at least arguably, about standing to keep the case, about the Supreme Court's jurisdiction to hear the case, and of course the court ends up appointing a law professor at Harvard, Vicki Jackson, who's one of the best-known scholars of federal jurisdiction in the country, appoints her as an amicus to argue these particular two issues and basically to argue them against your position, to argue in favor of the proposition that the court either ought not or cannot hear the case.
Represented by Patty Millett, exactly.
Right. And so how did you react to this complication? And on the one hand, it's great news that the federal government's on your side. On the other hand, this is a way in which the court might never get to the merits of the case. It could end up being a federal courts case instead of a constitutional law case.
I think my immediate reaction was, thank God I asked Pam Karlan to join the team. So we'd already been working on the merits, as you can imagine, and the minute that happened, I basically said to Pam, please do this. This is what your team will do, and she was glad to take it on. So the Stanford Law School Supreme Court Clinic kind of took it on. They wrote, we were involved in it, but they wrote that brief. Had we got an argument on jurisdiction, Pam would have argued it. That's what the parties had agreed to. I think strategically, we kind of saw it as more about the interplay between the Prop 8 case and the Windsor case as a serious issue, because, let me just take you guys back. So when the Supreme Court decides whether or not to take cases, they have these conferences. And in the Windsor and the DOMA cases and Prop 8 cases, they conferenced the cases, I think, at least 4 times.
Yeah, I think that's right.
It was torture. And so...
So just to interrupt, what that means is if you're a petitioner, you will have a sense for when your case is up for consideration by the court. And they meet in conference. It's just the 9 of them, no clerks, nobody else. But then you get an order list after that. And if the case is held over, they don't even really say held over for next one. It just doesn't show up on the order list. So Robbie and her colleagues and Edie would have been teed up to get an answer on a given day and then no answer. And then you wait again, and you don't know how long you have to wait, right?
Exactly.
Yeah.
So I think our suspicion was the fact that it took so many conferences is that there was probably some procedural wrangling among the justices among the 2 cases. So what I assume happens, I don't know, maybe we'll never know. I guess that the papers at some point may get released. But what I assume happened is they took the Prop 8 case. Well, they knew they had to take the DOMA case because it was a federal statute that had been declared unconstitutional. Then I think there were probably some justices who wanted to take the Prop 8 case, probably based on the notion that it was the best time then to defeat marriage equality. That wasn't going to get any better. And that was the time to do that. I then think that probably in response to that, certain other justices may have said, well, then we should add the standing issue to Prop 8, so there's a way not to reach the merits in Prop 8. And then, perhaps, what happened in response to that is some other justices came back and said, well, then we're going to add the standing issue in DOMA.
Yeah.
So I think we really saw it as part of that interplay. I don't think anyone, I mean, there were some real arguments on jurisdiction, but I think everyone was convinced that it would have been such a mess administratively and kind of embarrassing for the Supreme Court not to decide whether all these gay married couples out there actually were married under federal law in all these different areas of federal law, that we felt pretty good about it. Another thing is that throughout the case, every time we won at the district court, the Second Circuit, I kept calling the government and saying, when are we going to get our check? Like, is my check in the mail yet? And so we kind of even then had an instinctual thing that as long as they were withholding the check, I mean, I wanted the money, but as long as they're withholding the check from us, that would be
You've got an
probably be
injury,
sufficient,
yeah,
which is what the court concluded.
And that's just to remind folks, that was the very interesting aspect of the government's position, right? It can be summarized as enforce, but don't defend. So they were continuing to enforce DOMA's narrow definition of marriage by not issuing the tax refund check. But once that was challenged in court, they were putting up no defense of the statute. If they had not enforced and cut you the check, that would have mooted the case.
For sure.
But they weren't prepared to do that. They were going to, have to be told by the court in that sense.
It presented for law students in particular, presented a very interesting ethical issue because we had to decide what position we were going to take on jurisdiction.
Right.
And we realized that if we won on jurisdiction, you'd get our money back, she'd win her case because the Second Circuit ruling would stand. And we had a meeting with her and basically said, look, what do you want to do on this? There's an easy way to win this case. But you want to say that there is jurisdiction, in which case you could lose the case. And we had a long discussion. She was adamant that she wanted the Supreme Court to rule. But we made sure that she understood the implications of it.
That is fascinating. That's the kind of stuff that doesn't go into the brief, but that is part of the
Exactly.
strategy. Yeah. So the moots. You write in the book about the first moot in particular. So a moot, someone, whether it's her first argument before the court or her 31st, would have a moot session or two or three or four.
Or eight.
And you write about a pretty, I'm trying to think of the right adjective. I think the noun, intense is good. I think the noun you used in the book is that it was a fiasco, the first moot.
That's how we felt emotionally. So, the first moot was actually here.
Welcome back. You've come back.
Not in this room. Look, this was to be expected. I mean, it was the beginning, the first moot in the case. We were still kind of developing strategies. A lot of different people had a lot of different views, understandably, about how we should argue the case. The most prominent view that I remember kind of stuck in our heads was this sense that we should de-gay the case. And the reason for that, it's not crazy. The reason for that was that assuming the court wasn't going to decide based on heightened scrutiny grounds, which it did not, and didn't in Obergefell either, there was a sense that if you were in some version of rational basis world, that you should rely on these two cases at that time, Moreno and Claiborne, in which the court had technically overturned statutes technically on rational basis grounds. One case involved a mentally disabled people, and one case involved hippies. And there was a sense of kind of a hesitation, even then, this is in 2013 already, that maybe, being too gay was a mistake, and we should let the court kind of decide the case and along these lines and following these other two prior cases. And our sense, I think, was, first of all, even if we wanted to, we couldn't de-gay the case. Edie at that point was about as gay as you get. Gay as a goose, for sure. And I think it was also my sense strategically that, I understand there was a view among academics, there still is, strong view among academics that Justice Kennedy's jurisprudence isn't always the clearest, and I understand that. But my gut was that, at least with respect to the rights of gay people, he's been very strong. And so I think we should focus on the rights of gay people. So that's what we ended up doing. But it was quite a moot court experience. And there were tons of people in the room. So not only was this happening, but it was happening with an audience of probably 60, 70 people watching it. It was quite an experience. We had to take Edie home afterwards and kind of calm her down.
I do think that's a piece of the story worth underscoring, which is that by the time the case is before the court, and by the time you're actually preparing for oral argument, any skepticism about whether this was going to be the vehicle was, I mean, there was the potential complication of the standing questions, but that must have meant for you that it was simultaneously sort of lawyerly preparation for a case, which is what you need to be doing, and managing a set of community expectations that would be conflicting, and some of them driven by bad ideas and good ideas, and a hugely complicated piece, I imagine.
I mean, I think in a lot of ways, the Paul Weiss experience was incredibly helpful in this regard, because I'd grown up, and you don't have to be a Paul Weiss, but I'd grown up to learn that being a lawyer meant representing your client, and that you make all decisions based on what's in your client's best interest, and that's all you think about. And that was our rule. I mean, I had this poster on my computer that said, "It's all about Edie Stupid." And that was our rule. I mean, we made decisions based on would it help Edie get her money back or not, and that was it. And we certainly listened to advice about de-gaying the case or other kinds of advice that people in the movement had. We sometimes accepted it. But ultimately, having the purity of the decision being based on is it going to help us win or not, I think really simplified things in a lot of ways. At least we thought it did. I don't know if it did, but.
You talk in the book, I think one of the threads throughout the book is the role of your own faith in how you come to questions of equality here and in how you thought about the case. Talk about that.
Yeah, so, I had one thing that I think that the gay rights movement has been extraordinarily successful, obviously, and the pace of the change is unprecedented, as Trevor said. But the one area where I think we may have made missteps is in ceding religious arguments to the other side, in letting there be the impression out there that still exists today that religious people are anti-gay, or religious people are anti-gay rights, and that's the religious view. The truth is that's not the religious view. There are many religious people on the other side who believe, for example, as my faith teaches, that every human being was created in the divine image. And that means that every human being has dignity, and that dignity needs to be respected. And so it was really, part of our amicus strategy in this case was really to emphasize that. We had a very mainstream religious brief. I insisted, this is where you think about politics in the Supreme Court, because I didn't want any gay religious groups on this brief. I only wanted mainstream religious groups that basically made that argument. Some of those groups actually didn't even allow gay people to get married in their churches or synagogues. But their view was, regardless of what we do in our own temple or church, the government has to treat everyone the same. And I've thought about it more lately, and I don't know Justice Kennedy, obviously, and I've never talked to him about it, obviously. But I don't think the concept that he has of dignity that's so strong in these cases is necessarily divorced from that. I think it's a similar conception. And you can disagree religiously about how gay people should be treated and how their marriages should be treated. But for purposes of the Constitution, everyone has dignity that needs to be respected. So I thought it was incredibly important. Part of my religion is kind of Judaism in a lot of ways is a religion of the calendar and an organization of time. So just necessarily things happen during Jewish holidays on the case. So I argued the Second Circuit case the day after Yom Kippur. I begged the Second Circuit to give me another day to prepare, and they said no. So the whole day before I was in temple praying, and then the minute sundown, I was kind of crazy getting ready for the argument. We had Seder in Washington, D.C., Passover Seder, 2 days before my argument, in a hotel conference room in D.C. with my whole family, my wife's whole family, Edie's whole family, Pam's whole family. It was something I'll never forget as long as I live. So it ended up being very meaningful to me. But you don't have to be religious, obviously, to think this stuff is important. But I do think strategically, making people understand that it's not, the religious views cuts both ways, I think was very important.
How did you feel about the oral argument after it happened?
So I did, after the Supreme Court argument, what I do after every argument pretty much, and this is going to date me. It's like an old cassette tape. I kind of rewind it in my head and I play it back. And I remember thinking, okay, what, did I screw up on any questions? Would I have answered anything differently? And I remember thinking, no, I think I did okay. And I turned to Pam and I said, I think I did okay. What do you think? And she said, yeah, I agree. You did really well. And then the incredible emotion I had was, frankly, it wasn't joy. It wasn't ecstasy. It was relief. I was just so incredibly relieved, excuse the expression, that I hadn't screwed it up. That's the feeling I remember feeling all the way until we walked out of the Supreme Court building, at which point it was like being the closest I'll ever be to Mick Jagger, because when we walked out, there were just the throngs of cheering people saying our name, saying Edie's name was incredible. I should have tried to sing then, but that wouldn't have been, people would have stopped cheering had I said that.
Well, that's a better view on how it went, obviously, and you were right that it had gone well. There's a story, I think not apocryphal, about Robert Jackson, who before he went on the Supreme Court, was Solicitor General. He said for every argument he ever gave at the Supreme Court, he really gave it 3 times. There was the argument as he presented it in his mind the night before, which is well thought out, pretty well constructed. It seemed like it would be okay. There was the actual argument on the day, which was a total kind of bloodbath and, all kind of who knows what. And then there was the absolutely devastating argument that he made the night after as he thought about how he could have done better. But
I had a recent argument in
felt good about
Mississippi 2 weeks ago, and I've had that happen to me several times. I should have said that.
Now, you win the case. The opinion comes down. And tell me if you agree with this. If we just think about it's a win, and it's some really powerful language in the majority opinion. And if we fast forward to 2 years later, in the Obergefell decision, which is for the marriage equality movement a win, in its principles, to the constitutional law teacher in me, it's a very different opinion. That Obergefell, as I read it, and tell me if you agree with this, is principally about what I'll call a liberty interest. It's principally about the institution of marriage and individuals' right to participate in it on terms that they decide. And it seems in its language only secondarily about a principle of equality. Whereas I read Windsor as deeply steeped in the language of equality, which of course then affects DOMA's discriminatory treatment of gay people, but it's not limited to marriage at all necessarily. Do you read it that way,
Yeah,
as signing on to a principle going well beyond marriage?
I do, and we were very deliberate about that. I mean, some of the DOMA cases made a due process argument. We made no due process argument throughout the case. Our view was the people impacted by DOMA were already married, so they didn't have, the right to marry didn't matter. They were already married. The question was, how are you going to treat their marriages? And if you compare the brief that we put in, our red brief or merits brief in DOMA, to the Prop 8 brief and even to the brief in Obergefell, we didn't talk a lot about marriage. We talked about gay people. We thought that what we should talk about is the lives of Edie and Thea and how their lives were the same as anyone else's. And that had to be the basis for our argument as opposed to marriage is a good thing. I mean, I'm married. I have nothing against marriage. But it seemed to us we really wanted to be about, it was the opposite of the advice I got at the moot court, frankly, about not only were we not de-gaying the case, we kind of re-gayed the case over and over. And I think, Justice Kennedy talks a little bit about due process. Part of that's probably because of the Fifth Amendment in Windsor.
Right.
But I think that was very important. And, I wish there was more, like Justice Ginsburg, who recently commented on this, I wish there was a little bit more equal protection language in Obergefell than there is. Mm-hmm. That's what, when I cite them in court now, I cite them together to kind of bootstrap.
Smart. So let's talk about post-Windsor, post-Obergefell. Where do you see the fault lines in the legal struggles that you continue to be involved in here? You mentioned the adoption case that you worked on when you were clerking. Those questions still exist, and you're working on a case in that space, right?
Yeah, so they exist. I mean, it's a very different, the world from 1996. They exist today, but they only exist, well, I shouldn't say that. They exist in the state of Mississippi. which still has a statute on the books that says gay couples can adopt. They shouldn't exist in the state of Alabama, but sadly they do, because the Alabama Supreme Court just refused to recognize an out-of-state adoption by a lesbian couple, and there's actually a cert petition filed, I think, 2 days ago on that. But on the merits, I think these cases are pretty clear. When I argued the case down in Jackson, the judge, he had procedural issues with our case, but on the merits, he said he thought we were totally right. And the lawyer representing the AG and the governor basically said he didn't have a leg to stand on, which I thought was a pretty good concession from your adversary. I think the ultimate principle of Obergefell and Windsor together, or the consequence, is that the government can't discriminate against gay people anymore. No federal, state, or local government can enforce a law that says gay people get treated differently. They can't really treat gay people differently. There's going to be litigation about that. I call it the whack-a-mole syndrome. You have people like Kim Davis who want their 20 minutes of fame. In today's world, it's a lot more than 20 minutes with the internet. But ultimately, like every judge who looked at the Kim Davis argument thought it was silly. Justice Kennedy has essentially said it was silly in comments he gave at Harvard Law School. So it'll keep happening, but it's kind of like whacking the moles. The bigger issue, of course, is what happens in the private sphere. Some states, like New York, have laws that says you can't discriminate against gay people in private businesses. Most states do not. And there are these efforts underway in a whole bunch of states to pass these so-called Religious Freedom Restoration Acts, the purpose of which, not originally, but the purpose of which today really is to allow businesses to discriminate against gay people. I kind of look at this two ways. Kind of in the non-legal way, I'm convinced that there's really almost no appetite on the part of American business to have those laws. The last thing companies who want to make a profit and want to do well want is to have a store manager somewhere in Arkansas kick a little girl out of the store. I'm sorry, you can't have an ice cream cone, honey, because you have two moms. That's a PR and business disaster. And most of the lobbying, the effective lobbying that's being done against these laws is being done by the business community. So some of them will squeak through, but most of them won't, I would predict. In terms of private, kind of employment discrimination, the EEOC has taken the position that if you fire someone because they're gay, that's gender discrimination under Title VII. That needs to be tested in the courts, but it's an emerging theory. The obvious way to solve it is to get federal legislation. There is an act pending in Congress, the Equality Act. The president just endorsed it. I don't have high hopes that the Congress will pass that or anything else in the near future. On the other hand, I think in a lot of ways the debate's been won. Again, I think there'll be these kinds of issues that come up. But I think with respect to gay people, the issue's been won. I think obviously the emerging area now is trans rights. And you saw this in Houston, the civil rights legislation that just failed in Houston failed largely because it had trans protections, and the other side was able to use that very effectively. There was all these fears about bathrooms and things like that. And that's where I think you're going to see a lot of activity kind of in the years ahead. And there needs to be a lot more work done on that. Mm-hmm. There needs to be a lot more public education and work done.
It's interesting what you say about the preference of the business community. That itself, don't you think, is a kind of marker of how quickly things have changed, yeah. Right? The premise of your comment is that they are making an accurate assessment of their business interests and wanting nothing to do with a law that would allow yep. some local branch of a large nationwide or multinational company to invoke the protections of one of these state mini RFRAs. It feels like it wasn't that long ago that the accurate prediction of consumer response would have been very different.
Yeah, it's incredible. Totally agree. Even in Mississippi, we were just down there for a week. And the first time I went down, I expected all these protesters. The second time down, we'd heard rumors that there were these people who were very pro-Confederate flag that may be a problem, and we saw nothing. The entire time I've been down there, I've never seen, I'm sure people under their breath say or think things, but we haven't seen a single protester the entire time in the state of Mississippi. It's incredible. The Confederate flag is a much more live issue in Mississippi today, sadly, than gay rights.
Wow.
Yeah, it's incredible, right?
I have many more questions, but I want to leave some time for our audience. So why don't we open things up now? If you have a question, we have microphones in either aisle. Just, Karen, right there. There you go. Karen Schulman, the president of our Alumni Association.
Thank you so much for sharing that with us. It was just an incredible story, so I can only imagine how incredible the experience must have been, and what a great thing you did. I mean, it really, I don't know if you recognized that it would sort of change your life, but I'm curious to know that now that it's over, how has it changed things? I mean, are you, other than that moment when you were Mick Jagger outside the U.S.
Yeah.
Supreme Court?
She's still Mick Jagger pretty much everywhere at this
Yeah, I mean, it's changed Edie's life incredibly, obviously. Edie leaves her apartment and people come up to her wanting selfies or autographs. I mean, that doesn't happen to me very much, I have to say. Every once in a while on a blue moon, someone says, oh, I think you're a lawyer or something like that. The summer after we won, the summer of 2013, the Chagall paintings where the guy's kind of floating above his life in a state of ecstasy? That's how I felt. I just remember every day just feeling that way almost all the time. But we all have to go back to the ground. That's a good thing, frankly. I like the fact that I get up in the morning and I make my son breakfast and I worry about the dry cleaning and all the things that we all have to do every day. I like litigating regular cases. I'm thrilled to be doing that. I wouldn't turn another, civil rights case down. We're litigating pro bono in the state of Mississippi. But it's nice to be a real person too. So if that's the best way I can answer the question. Every once in a while, I still get that feeling of euphoria. Typically, when I see something that would have been totally bizarre, Trevor just mentioned it, only a few years ago, that's just so normal today, right? So if I'm in Mississippi and I see two gay guys walking down the street holding hands, every once in a while it hits me, and I have to pinch myself that this is what we all managed to do.
Norman. I think it'd be best, just wanting to, yeah.
Hi, I'm Norman Green. I'm an alum here.
Hi, thank
So
you.
here's the question. How much did it ever come through your mind that this is a situation involving judicial selection, that you started off with 4 judges in your pocket and 4 judges you were never going to persuade? Did you and Pam Karlan think about those issues and view this as a fight to change Anthony Kennedy's mind?
Well, that's part of what the D-Gay thing was about. Justice Kennedy he's unique in the sense that he has written all 4 of the major gay rights opinions at the Supreme Court. Romer, Lawrence, Windsor, and Obergefell. He's dominated this area unlike any other Supreme Court justice that Trevor, you might know, that I'm aware of.
I think that's fair, yeah.
So as you can imagine, in any high-profile case today, whether it's gay rights, pro-choice, voting, it doesn't matter. The advocates are focused on Justice Kennedy. That's just an inevitable result of the court's current politics. We were incredibly focused on Justice Kennedy. We had a section in our briefs that I called it the checklist section, kind of between the heightened scrutiny section and the rational basis section, that I thought were the reasons that he should use to kind of hold DOMA unconstitutional on something higher than the lowest level of rational basis. He called it in Windsor more careful consideration. Some people call it rational basis with bite. But the arguments I used, we had 3 were very much based on Romer and his prior decisions. So we were incredibly focused on that. We thought that he was going to kind of vindicate his prior rulings in Lawrence and Romer, and he did. But that's not a gay rights issue. That's a Supreme Court issue. He recently said, he doesn't swing, cases do, is what Justice Kennedy recently said at Harvard Law School. But the fact of the matter is, however you want to call it, his vote is the vote that determines, and I'm sure that's going to happen this term too, a huge number of kind of cutting-edge cases.
Yeah, I don't suppose anyone expected that Justice Kennedy would find himself in dissent in that case. Wherever he was going to be where the majority was, yeah. Right? Other questions? Yes?
Hi. Do you think that there's still a possibility to get heightened scrutiny for gay rights cases? And what do you think that route might look like?
Well, so we have it in the Second Circuit in an incredible opinion by Dennis Jacobs in Windsor.
NYU graduate.
Fabulous. We have it in the Ninth Circuit. So both the Ninth Circuit and the Second Circuit are clear on this. I think other circuits are going to follow. I mean, there was the judge I just argued in front of a pretty mainstream conservative federal judge in Mississippi, and he seemed open to the argument. I mean, I think the prior cases that in the circuits that have all held that gay people don't get heightened scrutiny, I think people will realize are no longer good law. And so I think a lot of the circuits will reconsider that if they have to. I mean, they need a case in which it comes up, and I'm not sure they're going to get that case, but if they have to. In terms of the Supreme Court, with this court, I think the answer is probably no. They had a chance, certainly in Obergefell, to do so, and they did not. I don't think it's necessarily about gay people. I think it's about their views about heightened scrutiny in general. I think there's a reluctance to extend that doctrine and maybe even a desire to restrict it in general. So they probably won't extend it to gay people, but clearly the level of review that Justice Kennedy is doing in Windsor and Obergefell is not optical rational basis, for sure. You know, again, it's been called many different things, but it's clearly something higher. But he's not, even though it's interesting, he talks about many of the factors that are in that famous footnote in Caroline Products in Obergefell. He just doesn't talk about them the way you would expect, kind of in an organized 1, 2, 3, 4 way. But he talks about historical discrimination against gay people. He talks about the fact that you're kind of, it's part of who you are. It's an innate characteristic. He talks about kind of the fact that gay people aren't going to get it politically what they want. So he talks about them all, but he's not doing it in kind of a classic heightened scrutiny analysis.
This is a point of great frustration to constitutional law students who wish it were easier to categorize the level of scrutiny actually going on. But I think you're exactly right. If you think back to the Lawrence decision, another, as you mentioned, Romer, Lawrence, Windsor, Obergefell, all written, majority opinion is written by Justice Kennedy. Lawrence, too, is certainly not clear as to the level of scrutiny being applied in the course of striking down that Texas anti-sodomy statute as unconstitutional. Justice Scalia says in dissent, look, it's either heightened scrutiny or it's plain vanilla rational basis, Williamson versus Lee optical rational basis. And because the court doesn't say heightened scrutiny, it must be rational basis. And that premise, I think, tell me what you think, I think just doesn't describe how Justice Kennedy does these cases. He's applying something more substantial but not naming it. And you won in Windsor with a sort of unnamed, more searching kind of scrutiny between those two.
Totally agree.
Good.
Totally agree. But I think you're going to see circuit developments. I mean, I do think if there are the right cases, if there are actually cases discriminating against gay people,
Right. Yeah.
which I'm not so sure that's going to happen, but if it happens, I think you'll get circuits will kind of fall one by one.
It's interesting, the win may turn out to have been so comprehensive that
Yeah.
the court won't even really
Yeah.
have occasion to need to do
Right.
it, right? Which is an interesting way to think about social change and doctrinal development.
The other thing I should say is when I got up in the Second Circuit, and we had originally thought the panel, so we had a bunch of motions to expedite in the Second Circuit, and those motions all got decided by Judge Lynch. And we thought that since he had said on the motions that he was going to be on the panel. And then when we got the panel, which did not include Judge Lynch, and we thought he would go for heightened scrutiny.
Yeah.
Then when we saw the panel that did not include Judge Lynch, we thought we had no shot at heightened scrutiny. And when I got up to argue, and all Judge Droney and Judge Jacobs wanted to talk about was heightened scrutiny, I almost fell over. I mean, I remember thinking like, okay, like you want to talk about this? I'm glad to talk about this. But I was really surprised. That was the first circuit to ever do so.
The Jacobs opinion is very clear, actually, about what triggers heightened scrutiny.
Yeah.
Constitutional law students love that
Yeah.
opinion.
Oh, it's a wonderful opinion. And he's admitted to me since then, and we talked about it recently, that, I mean, we all knew that he's known to be a very fast judge. He gets decisions out very quickly, but that decision was rushed. And it's because he knew that the Supreme Court was having these cases in front of it, and I'm very, very, obviously very, very glad that he did so.
That's interesting. Robbie, this has been just fantastic. You know, when Ruth Bader Ginsburg was nominated to the Supreme Court by President Clinton, he called her, many of you will remember or will have seen this, he called her the Thurgood Marshall of the women's rights movement. And
was.
she was, in a way,
was.
someone who had lived the experience of gender discrimination and was the lawyer who led the effort to overcome it in constitutional doctrine and completed the task when she was a justice on the court, of course, in the VMI case. I think there's a very good reason to believe that you, Robbie, are the Ruth Bader Ginsburg of the gay rights movement.
I agree with you completely about Justice Ginsburg, but I will not take any comparisons between me and her.
Well, all I have to say, and future presidents take note, is that if the parallel holds, then if there's anything that remains to complete the task, we just have to get you on the court.
Oh, God.
Thank you.
Thank you so much. Thank you.
We're going to open a reception here. I hope you'll join us. Thank you again for being here. Thank you, Karen Shulman and the Law Alumni Association.
With interest. And by the way, a lot of this and more is in my book. If anyone wants, I'm happy to sign copies if people want to buy it. It's a good Hanukkah present.